Rule 28, Procedure in case of anticipation by prior publication. Rule 28 describes what should be the procedure that the controller should follow in cases of anticipation. And we saw in section 18 the powers of a controller in cases of anticipation. We saw that where there is a case of anticipation, the applicant can either show to the satisfaction of the controller that the claim is actually the priority of the claim of his application is before the date of the prior art document that is cited against it, or he can amend his complete specification to get over the objection. These are the two things the applicant can do. In some cases, we also saw in section 18, the controller can add a reference to an application which was published after the priority date, but which was filed before the priority date of the patent, applicant's patent. Now, in Rule 28, the procedure is described. Rule 28.1 states that if the controller is satisfied after investigation under section 13 that the invention so far as claimed in any complete specification has been published in any specification or other document referred to in clause A of subsection 1 or subsection 2 of the said section, that is section 13. So, 13(1)(a) or 13(2), any of the documents mentioned in this, which are largely we know that documents in the form of a complete specification or any other document, the controller shall communicate the gist of the specific objections and the basis thereof to the applicant, and the applicant shall be afforded an opportunity to amend his specification. So, once the controller finds that there is a case of anticipation, the controller shall communicate the gist of the specific objections. Now, we do not understand, or the rule here is not clear as to how that communication can happen. It just says the controller shall communicate the gist of the specific objections and the basis thereof, why those objections were raised, which means if there is a prior art document and if the document is prior filed patent specification, the controller will have to give the number, and if there is a particular claim, then he would mention that claim so and so of your application is anticipated by claim so and so of this prior art. So, that is what we understand as gist of specific objections and the basis thereof. So, that the controller will have to communicate to the applicant. So, when the applicant receives this, if the 28 rule 28.2 says, if the applicant contests any of the objections communicated to him by the controller under sub rule 1, or if he refiles his specification along with his observation as to whether or not the specification is to be amended, he shall be given an opportunity to be heard in the manner if he so requests. So, we saw that the controller communicates, the applicant can respond to the objections, and he can also request for an hearing. Opportunity to be heard is if he makes a request for hearing, the controller will have to hear him. So, this process could come as an objection raised by a controller, and wherever an objection is raised by the controller, the applicant is afforded an opportunity to clarify the objection. In addition, the applicant can also request for a hearing, and there are provisions under the Patents Act where a hearing can be requested and the manner in which hearing should be conducted. Provided that such request shall be made on a date earlier than 10 days of the final date of the period referred to in subsection 1 of section 21. Now, section 21, we have not come to that section yet, deals with the timelines for putting a patent in order. Section 21 is titled Time for Putting Application in Order for Grant. Section 21's fundamental premise is when the office communicates an objection by way of the FER or by subsequent objections, there is a time within which the applicant will have to respond. That timeline is given in section 21. And now that we have an expedited examination, some of the timelines have even become shortened. So, there are timelines have become shortened in the case of an expedited examination. So, section 21 talks about the timelines for putting the application in order for grant, the time that is given to put the application in order so that it can be granted, which means the time given to the applicant to carry out the objections raised by the controller, to respond to the objections in a manner in which the controller is satisfied to grant the patent. So, this timeline, the proviso here tells us that before the request for hearing has to be made 10 days earlier to the final date of the period referred to in section 21(1). Hearing, when you make a request for a hearing, when you make a request for a hearing, the controller will have to make an arrangement for the applicant to be present in his office. So, hearing takes some time. So, that is why you find a 10-day period that is given before the expiry of the final date. You have to make a request for hearing. There are other provisions of the Patents Act where if you request for a hearing, say or when a hearing is communicated, there is a similar notice period so that the parties and the controller can prepare for the hearing. So, hearing is not something that is given without advance notice. Hearing should under the Act always be preceded by a notice period. Subrule 2 further continues, provided further that a request for hearing may be allowed to be filed within such shorter period as the controller may deem fit in the circumstance of the case. The controller may have a shorter period for the applicant to request for a hearing, and that is left to the discretion of the controller. In a normal case, you can make a request 10 days before the final date of the period under section 21, but in some cases the controller can allow a shorter period. So, the controller, when he communicates the gist of the specific objections, the controller can also say respond to me in 30 days time or respond to me in 2 weeks time. So, this provision allows the controller to set a shorter period. For instance, if the controller feels that the objection can be addressed much quicker, he need not wait for the entire time period to end, or if the controller feels that there are other applications of similar nature pending and he wants to take them all together, he can ask a response to be given at a shorter notice. So, there could be various administrative reasons why a controller can insist on a shorter period, but that power is given under Subrule 2. Subrule 3, if the applicant requests for a hearing under Subrule 2 within a period of 1 month from the date of communication of the gist of objections, or the controller considers it desirable to do so, whether or not the applicant has refiled his application, he shall forthwith fix a date and time for hearing, having regard to the period remaining for putting the application in order or to the other circumstances of the case. Now, if a request for hearing is made within 1 month, so the gist of objections is communicated to the applicant by the controller, the applicant receives the gist of objections and within 1 month he requests for a hearing. So, there is a 1 month time period for him to request for a hearing. The request shall be made within the period stipulated under 21. There is a period stipulated within which the prosecution has to end. 10 days before that is the timeline, it is the last time period given for the applicant to make the request. He cannot make, if the timeline is ending on January 31st of a particular month, he cannot make a request for hearing 2 or 3 days before that. There has to be a clear 10 days before which he can make a request. Now, Subrule 3 tells us that when the gist of the objections is communicated, the applicant can make a request for hearing within 1 month from the date of communication. Now, if the applicant makes a request, it has to be within 1 month of receiving the communication containing the gist of objections, the controller shall fix a date regardless of whether the applicant has refiled his papers. Now, when an objection comes saying that there is a particular prior art, one recourse for the applicant is to amend the specification. So, that is what we call refiling his application. He has to refile his application, he has to file that amendment. Whether or not he has refiled it, whether or not he has carried out the amendment, the controller can go ahead and fix a date and time of hearing. Now, the date and time of hearing will be fixed taking into consideration the remaining time for putting the application in order for a grant. Now, I will give you a hypothetical situation. Assume that when the FER is sent for the first time, the applicant has 1 year to reply, or let us say 6 months to reply. The applicant replies within a month. So, there is still 5 more months time period left. The controller further communicates and says that there is an objection on anticipation. Now, this happens in the second month. The applicant can make an amendment and request for a hearing within the third month. He is entitled to do that. Now, when he does that, when he makes a request, the controller will now have to set the hearing keeping the final date in mind. He knows that there is a 6-month period beyond which, within which the changes have to be carried out. So, the controller will always fix the time period keeping this time in mind. At what stage is the patent application in, and how much longer does the applicant have to put the application in order for a grant. We saw that in Rule 24B, examination of application, we saw the timelines. We also saw in Rule 24C what are the timelines in the case of an expedited examination. Now, Rule 24B and 24C actually expand on the timelines mentioned in Section 21. Section 21 tells you that if the controller gives you time to do something, you have to do something within that time. If you do not do it, your application will be treated as abandoned. In this hearing, when a specific objection is raised on anticipation, the applicant can reply to them and also request for a hearing. When the applicant requests for a hearing, it should not be at the end of the time that is allocated to him. It should be at least 10 days before the end of the time allocated to him. That is one thing. Secondly, when he receives the objection, the hearing has to be requested within 1 month of receiving the objection. So, these are two different things. I receive the communication from the controller, within 1 month I will have to request for a hearing. But that request should not be in the end of the time period allotted to me. If there are only 10 days left, then I should do it immediately. Upon receive, I should not wait for a longer time, because the law says that there has to be a 10-day period before which you can, before the expiry of your allocated time to make this request. Now, the date and the time will be fixed by the controller, keeping this timeline in mind. So, the timeline will largely depend on Section 21, Rule 24B and Rule 24C. This will decide how much time an applicant has to put the application in order for a grant. Now, sub-rule 4, the application shall be given 10 days notice of such hearing. I already mentioned that there is a notice period for hearing, and it is 10 days in this case, or such shorter notice period as appears to the controller to be reasonable in the circumstances of the case, and the applicant shall as soon as possible notify the controller whether he will be attending the hearing. Now, once a request for hearing is made by the applicant, the controller can give notice of the time and date of hearing. So, I as an applicant, if I make a request, I can't make a request and end up in the patent office, because I am only making a request for the hearing. I am not going to ask the controller to fix the date. Fixing the date and time we saw in the earlier sub rule is given, it is a discretion of the controller, because the controller has his own administrative duties. The controller now, and he has many applications on which he is prosecuting. So, the fixing the date and time has to be done by the controller, and that is communicated to the applicant. When that is communicated, the controller can either give a 10 days notice period. Notice period is, he sends a letter saying the hearing will be after 10 days, or if the circumstances require, it can be a shorter period. Now, assume that everything is going to happen, an objection is raised just 15 days before the allocated time. The allocated time ends in 15 days. Controller sends an objection just 15 days before that. Now, the 1 month period will have no meaning now. You have to move very quickly because you only have 15 days period, and the applicant knows that he has only 15 days period, and say he communicates on the 5th day. Now, the controller will not have time to give a 10 days notice. So, in such cases he can give a shorter notice. So, that is the power is given in sub rule 4. Ideally, the notice period for a hearing, the letter communicating the date and venue of the hearing will have a 10-day period before the hearing, ideally. But if the controller needs to give a shorter period, he can do that. Sub rule 5, after hearing the applicant or without a hearing, if the applicant has not attended or has notified that he does not desire to be heard, the controller may specify or permit such amendment of the specification as he thinks fit to be made, and may refuse to grant the patent unless the amendment to the specified or permitted, unless the amendment so specified or permitted is made within the period as may be fixed. So, after the hearing, in the hearing, the applicant will put forward the case that he has submitted, either trying to satisfy the controller that the prior art is different and it does not affect his priority, or filing an amendment. So, once the applicant does that, sub rule 5 says that the controller may specify or permit such amendment as he thinks fit. Controller may ask for another amendment, or the controller may allow that amendment. That is one thing he can do. Or if the controller is not satisfied, he may refuse to grant the patent unless the amendment so specified is made within such period as may be fixed. Now, this language is taken from the language of section 15, and we saw in section 15 the controller can require an amendment. If the amendment is filed, then the patent is granted. If the amendment filed is not satisfactory or no amendment is filed, then the controller can refuse to grant a patent. So, this sub rule is, though it comes in the context of anticipation, the hearing happens under section 15, and the order that is passed also happens under section 15. So, this sub rule talks about the power of the controller to amend and the power of the controller to refuse to grant and patent. Both the powers are contained in section 15. Sub rule 6, which was introduced recently, states that the hearing may also be held through video conferencing or audio visual communication devices, provided that such hearing shall be deemed to have been taken place at the appropriate office. Now, the appropriate office is defined as the office where the application is filed and the office that is prosecuting the application. Rule 4, appropriate office. The appropriate office of the patent office shall, 1, for all proceedings under the Act, be the head office of the patent office or the branch office, as the case may be, within whose territorial limits A, the applicant or the first mentioned applicant, in case of joint applicant, normally resides or has his domicile or has a place of business or the place from where the invention actually originated. Now, if all these things are there, appropriate office will be where the applicant resides or has its domicile or has a place of business, or where the invention actually originated, or the applicant for a patent or a party in the proceeding, if he has no place or business or domicile in India, the address for service in India given by such applicant or party is situated. Now, so if the applicant does not have a place in India, he does not do business in India, he does not reside in India, or he is not domiciled in India, we know that foreigners can file applications here, then the appropriate office will be decided by the address for service in India. Now, if a multinational company engages a law firm based in Chennai, then the address for service in India will be the address of the law firm in Chennai. So, obviously, the application will be filed in the Chennai branch of the patent office. So, the same multinational company for a different application can engage a law firm based out of Kolkata. In that case, they will give the address of communication as that of the law firm in Kolkata, and the appropriate office for that application is going to be the branch of the Kolkata patent office. The appropriate office, once decided in respect of any proceeding, shall not ordinarily be changed. So, if an application is filed in Chennai because the multinational company engaged a law firm based in Chennai and that was the address given, later on the address, the multinational company feels that we should now engage with the Calcutta law firm and it wants to transfer the file from here. So, it will give a fresh authorization to the law firm based in Kolkata, but the file will not be transferred. The file will continue to be a Chennai file. It will not be ordinarily be changed, just because we saw that the sub-rule 2 deals with instances where the appropriate office is decided based on the address of service. So, 4.2 just says that just because the address of service keeps changing, the appropriate office will not change. It is only the address of service as on date of filing. After that, it will remain the same. 4.3 states that notwithstanding anything contained in sub-rule 2, the controller may transfer an application for patent so filed to head office or, as the case may be, branch office of the patent office. The controller has power to transfer files regardless of the fact that once a file is filed in a particular office, it remains the appropriate office. Regardless of that, the controller has power in some cases to transfer files. 4.4 states that notwithstanding anything contained in sub-rule 1, further application filed in section 16 of the Act shall be filed at the appropriate office of the first mentioned application only. This is a requirement only for divisional application. A divisional application has to be filed in the same office or as where the parent is filed. There were some cases where the divisional was filed in a different office and the parent was filed in a different office. Now, this creates some administrative difficulties because the controller or the patent office may not know that there is a divisional, and we saw in 24B that if a divisional is filed later on, then the divisional should get into a fast track publication and examination so that they can be examined together. The parent and the divisional can be examined together. There is a provision in 24B to expedite that. So, here the patent office clearly says that you cannot file a parent application in one office and choose another office for filing a divisional. This came in 2013. Before 2013, there were some cases where an applicant would file a parent application in one office and choose to file a divisional in an entirely different office. So, this addresses that issue. 4.5 all further applications referred to section 16 of the Act, filed in an office other than the appropriate office of the first mentioned application before the commencement of the Patents Act 2012 shall be transferred to the appropriate office of the first mentioned application, which means the patent office acknowledges that there was a problem. 5 actually acknowledges a problem for which subrule 4 is the solution. Subrule 4 says you cannot file a divisional in a different office than the parent where the parent was filed. 5 says there were some cases where it was filed, we will transfer it to the where the parent is. So, the child will be transferred to the office where the parent is. So, 5 only takes care of that. So, this acknowledges a problem that it shall be the divisional and the parent have to be in the same appropriate office. Now, let us come back to the rule. Rule 29, procedure in case of anticipation by prior claiming. Rule 29(1) deals with the procedure that has to be followed when there is an anticipation by prior claiming. In Rule 28, we saw that Rule 28(1) there is an investigation and the controller is satisfied that the investigation that there are certain objections. The objections are communicated and the gist of the specific objections are communicated and an opportunity is given to amend. Now, the applicant can contest that or refile his specification and he can request for a opportunity to be heard, and he shall be given an opportunity to be heard, and there are timelines for the hearing. After the hearing, the controller may either accept the amendments to the specification or refuse the amendment. Now, this is broadly the procedure under Rule 28. Rule 29(1) states that when it is found that an invention so far as claimed in any invention of a complete specification, which means I have said this is the short form, this is when it is found that a claim is claimed in any claim of any other specification falling within 13(1)(b), the applicant shall be so informed and shall be afforded an opportunity to amend. So, here the procedure is quite simple. There we saw in 28, but to understand 29 in detail you will always have to compare it with Rule 28. In Rule 28 we saw that what is communicated is the gist of the objections, and the objection comes under section 13. The gist of the specific objections is communicated. Here what is communicated is the fact that something is prior claimed. What is claimed in the applicant's specification has been claimed in another specification, that is all. It is a case of prior claiming. So, the applicant shall so be informed and shall be afforded an opportunity to amend. Just two things here: inform the applicant that there is a prior claim and give him an opportunity to amend. 29(2), if the applicant's specification is otherwise in order for grant, and otherwise in order for grant you will always go back to section 43. Section 43 is the cross reference for Rule 29(2), because whenever we see the word other order for grant, an application is made ready for a grant or made in order for a grant or becomes ready for a grant under section 43. Section 43 is a provision which grants it, and it has to satisfy all the objections that could be raised, and only when it overcomes all the objections it is in order for a grant. And an objection under clause B of subsection 1 of section 13 is outstanding. The controller may postpone the grant of the patent and allow a period of 2 months for removing the objection. Okay. So, when there is an outstanding objection, we understand this as it is otherwise it is ready for a grant, but an objection is outstanding. A 13(1)(b) objection is outstanding. The controller will postpone the grant and give a period of 2 months for removing the objection. So, you could have a question that under Rule 29 or under section 13(1)(b), if there is an outstanding objection under section 13(1)(b), what is the time period that the controller shall give for removing the objection. So 1 month, 2 month, 3 month, 4 months. So you could have a objective type question based on this, because it's a very particular provision. It is much different from rule 28. Rule 28, the controller does not give any time. Now the reason is, under rule 28, it is an investigation of anticipation by prior publication, and prior publication will involve mapping the claim of the applicant's specification to a published material. It need not be a claim. Whereas in 29, there is an existing claim. Existing claim is to be, so in 29 we are talking about a claim to claim comparison. So it is much more specific. There is no need for anyone to read a document, understand the scope of the document, interpret the document. Here it is just claim to claim mapping. Because it is claim to claim mapping, the controller can be very specific in his requirement. Within 2 months, overcome the objection. I am postponing the grant for 2 months, overcome it by remove the objection. So the procedure is shorter and much more specific because it is a claim to claim mapping. Whereas in anticipation by publication, it need not be a claim to claim mapping. In most cases, it is going to be a claim mapped with another document, another publication. Rule 30, amendment of complete specification in case of anticipation. 31 states that if the applicant so requests at any time, or if the controller is satisfied that the objection is not removed within the period referred to in 29(2), which we just saw, a date of hearing the applicant shall be fixed forthwith, and the applicant shall be given at least 10 days notice of the date so fixed. The applicant shall as soon as possible notify the controller whether he will attend the hearing. Now, you can draw a list of types of hearing under the Patents Act, and you will be surprised to see under how many provisions you can have different hearings. The default hearing provision is under section 15. Any objection, the controller is inclined to refuse an application, he can call for a hearing, and based on that, if he asks the applicant to amend the specification, or if he asks the applicant or if he rejects the application, or if he grants the application, if he is going to write an order, I am granting the application because of this reason, they have overcome it, I want the application to be amended based on this reason, or I am rejecting the application based on this reason, they will all be orders under section 15, because the power to refuse an application comes only under section 15. So, and we know that the controller shall not exercise his discretion without giving a hearing. So, in 15, hearing is compulsory or mandatory. We can say that under section 15, if the controller has a section 15 proceeding, hearing is mandatory, because there is a provision under the patents rules, rule 129, which states that the exercise of discretionary power by the controller shall be done only after affording a hearing to the party who would be affected. So, rule 129 mandates the controller to have a hearing. So, under section 15, if the controller asks the applicant to amend the specification, he is exercising his discretionary power, or if he wants to refuse the application, again he will be exercising his discretionary power. He has a choice to do things in different ways, that is where discretion comes in. So, wherever he can exercise his discretion, there he has to give a hearing. Now, there are cases where the controller cannot exercise discretion, there is no need for a hearing. The applicant files a request for examination. There is no discretion required on the controller has to post it for examination. He cannot now hear the request for a hearing, or I want to know why you want this to be examined, that question does not arise. So, there is no discretionary power when for many things under the Patents Act. It is a procedure, there is a rule, the controller has to do the next thing. But wherever he can exercise discretion, we understand discretion as a choice either to do one thing or another thing. Under 15, he can grant a patent, ask for amendment, refuse the patent application. So, he can do 3 things. So, that is where discretion comes in. So, where he exercises discretion under rule 129, we know that he has to give the applicant or a party a hearing. This is to satisfy the principles of natural justice. It is a principle in law, and the Indian legal system recognizes that principle, that if you have to take a decision, if a government authority has to take a decision in a matter pertaining to a third party, an applicant who has gone before the government authority, he has to hear the other side without whatever decision he passes. Without hearing the other side, without hearing the party concerned, if he passes a decision, then that is what we call, there is a violation of the principle of natural justice. The principle of natural justice tells us that you should not pass any order without hearing the party who will be affected. Audi alterum partem, that is a principle in law which says that you should not pass any order without giving an opportunity. You have to call that person, give him an opportunity, hear his case, and then pass the order. So this provision 129 tells us that there has to be a hearing. So, we were on the point that if you enlist the hearings under the Act and the rules, you will be surprised to find that there could be a hearing under section 15, there could be a hearing under section 14, you could have hearings under section 25(1), hearings are mandatory under section 25(2). We saw in rule 30 there could be a hearing. So, this is a specific hearing, and this is for removing an objection under rule 29(2). There can be a hearing. So, this is a specific hearing, we understand this as a specific hearing. 32 states that after hearing the applicant and without a hearing, if the applicant has not attended or has notified that he does not desire to be heard, the controller may specify or permit the amendment of the specification as will be to his satisfaction to be made, and may direct the reference to such other specification as he shall mention shall be inserted in the applicant's specification unless the amendment is made or agreed to within such period as he may fix. So, after the hearing, the controller may specify or permit the amendment to his satisfaction, or he may direct a reference to be made, inserted in the specification, because we had seen that the controller also has the power to make references in case of anticipation.